I salute you all. Thanks for being on and thanks for watching. Today we are under the course unit of criminal procedure, and what we are looking at criminally or the criminal procedure, basically today we are going to look at pleas. You understand? Pleas basically as a special unit. And for criminal procedure, basically you must know the TIA and the MCA. That is the Trial on Indictment Act and the Magistrate Court Act. Bear in mind the difference between the two is that the trial and indictment is in the TIA is in the High Court, while the MCA is in the magistrate courts. So that is the difference that I can give, or the point that I can give, and you bear the difference between the two. So today we are under pleas, and the discussion or the discussion that I can give about pleas is that a plea is an answer to a charge made by somebody who normally is called the accused in the criminal in a criminal case. You get? So it is like it can be an admission or a denial of a charge. That is a plea. You get? An admission or a denial of of a charge. That is a plea. It can be a defense or an objection to the charge being brought against the accused. A plea is taken by the accused person in a criminal offense. You get? So bear that in mind. That's about a plea, the definition that I can give for us to understand what a plea is. And here what you have to know, or the overall essence, what we have to know is that the accused person is the person who is entitled to take a plea. You get? Anyone else cannot take a plea on his or her behalf. When you read the case of Basanyi Ganji versus R, court says that it is only the accused person that is entitled to take a plea. You get? Then to deal with a corporation, when it is a corporation, a representative of that corporation is the one that is entitled to take a plea. If at all I've sued a corporation, that is related to section 53, subsection 1 of the Magistrate Court Act talks about that. And what you have to bear in mind that it must be in written. If it is a written plea of guilty, it may be accepted in absence of the accused once it is made in writing. You get? For a plea of guilty, it may be accepted in absence of the accused once it is made in writing. You get? There's a case of R versus Hussein Muhammad or Mot. That is a good case that backs up what I'm trying to put in mind. And you also read to section 52, subsection 1 of the Magistrate Court Act portrays that or brings that vividly. So put that in mind. And there's where the victim refuses to take a plea, what is the repercussion? If the accused person refuses to take a plea, the way forward is that the court will order a plea of not guilty, because silence does not amount to guiltiness. So if you refuse to take a plea and you are the accused person, the court will only order a plea of not guilty, following section 124, subsection 4 of the Magistrate Court Act portrays that thing very well. You get? And bear in mind, or what you have to bear in mind. And also there is where that they say that where unfitness, where the accused person is unfit of to take a plea. Relate to section 113 of the MCA and section 45 of the TIA, Trial and Indictment Act. If court has reason to believe that the person is unfit to take a plea, so court is in charge of the responsibility of inquiring into the matter. Relate to the case of Kaplotwa, son of Tarino versus R. Relate that case is a good case. Then when you also move forward and see that while recording a plea, what is necessary. When we read the case of Adan versus Republic of 1970, is it 1973? So actually what you have to know about that case, or what you have to put in mind in that case, is that when recording a plea, first of all, a plea must be voluntary. You get? And it must be in front of a magistrate. or in front of court. It must be done voluntarily. Related to that case of Adan versus Republic, it is very, very a good case in terms of pleas. That is the leading case actually, Adan versus Republic. It is very, very vital case concerning such matters. So we have various categories of pleas. You get, we have a plea of guilty, plea of not guilty, plea of pardon, plea of something. Is it something like that? As we shall see, it is. Is it outrageous? It is a kind of hard word, but those are some of the categories that we have for pleas. I'll start with a plea of guilty. A plea of guilty, basically, as you hear that a plea of guilty, here basically you are trying to admit that you are what? You are guilty. In this essence, you are trying to admit that, you know what? I'm guilty of these charges. You are accepting the what? The charges. That is to deal with a plea of guilty. Relate to section 124, subsection 1 of the Magistrate Court Act, whereby that a person can be asked whether he or she is guilty, and he or she what? Admits. So relate to the same for a plea of guilty. You are just merely accepting what? The charges. Then we have a plea of not guilty. A plea of not guilty. A plea of not guilty, basically, I made an error. For a plea of guilty is under section 124, subsection 2. Then a plea of guilty is a plea of not guilty is under section 124, subsection 1. That is not guilty. For guilty is under subsection 2, so of the MCA. So basically, note that in mind. Then we also have a plea of outrageous convict or outrageous acquit. Basically deals with double jeopardy, that a person cannot be convicted twice on the same offense. Then we have what they call a plea of pardon. When you follow Article 28, Clause 10 of the Constitution, say that no person shall be tried for a criminal offense if he or she shows that he or she has been pardoned in respect of that offense. That is Article 28, Clause 10. Then when you read Article 121, Clause 4A, talks about the president is the one entitled to give pardon to the criminal offenses. You get, there's a case of Ribalachi Kiria of 1984, where it was premature for the court to ascertain or to entertain what amounted to a special plea of pardon, of presidential pardon, under the prerogative powers of mercy exercisable by the president, as the indictment had not been filed and the trial had not been commenced. Under this case, they speculated that the president can only give pardon once the indictment has been filed and the trial has been concluded, has commenced already. That's when the president can give pardon. He cannot give pardon before trial or before the commencement of the indictment. So basically, note that in mind. Then there is also what they call amnesty. Amnesty is under the plea of what? The plea of pardon. And this is the pardon, forgiveness, exemption, or discharge from criminal prosecution or any form of punishment by the state. That is amnesty. When you read section 1 of the Amnesty Act, chapter 294, talks that very well, or brings it out very well. So put that in mind. So basically, note that in mind. That's basically, it is under the Amnesty Act, chapter 294. Then we also have the change of plea. Because however much a person can take a plea, but there are certain factors that may lead to the change of what? Change of a plea. What do I mean, or what am I trying to relate is that someone can reach at an extent and changes what? And changes his or her plea. There are three core grounds someone can change a plea. Following the case of David Kamundi versus Republic, where the court held that there's no any particular provisions of law that provides for change of plea, but equally there is no any provision to prevent a plea from being changed before the court becomes factus official. Factus official says that before court makes its final judgment, you get, towards following the plea. There are three major cores. First of all, one of it where the accused may have misunderstood the charge may lead to change of plea. Secondly, where the accused didn't had a language problem when they are reading the charges to him or her, there can also be what? Change of plea. And where also the plea or the plea of guilty had been entered in error, it should be withdrawn and the plea of not guilty entered. You get? So note that in mind or bear that in mind. Those are the three genuine grounds where a plea can be what? Can be changed. So put that in mind or bear that in what? In mind. And when we move further, that's basically a kind of a plea or a plea. Basically what you have to bear in mind is that under these pleas you must be ascertained more so on the TIA and the MCA. Criminal procedure is about the two. Get the TIA is in the High Court, the MCA is in the magistrate what? The magistrate courts. So that is the pleas that I can talk about or that I can say under the criminal procedure. So thank you very much. Thanks for watching. Thanks for being on. Subscribe to the channel and like the video. Thank you very much.